Today's mood was tense, but polite until the microphones turned on. Then all bets were off. I'm Ethan Blake, and I saw civility implode on cue.
Senator Kennedy to kick us off.
Thank you, Madam Chair. Judge Dudick, did I say that name right?
That's correct, Senator.
All right, what's the warrant requirement?
Well, before the court would issue a warrant, you have to assess to make sure that there's probable cause to either search the place.
When's a warrant required?
Excuse me?
When is a warrant required?
The general rule is a warrant is required any time that the government wants to search a person, place, or thing.
Could you speak into the mic?
Oh, I'm sorry, Senator. Yeah, I said the backdrop rule is that a warrant is required any time the government wants to search a person, place, or a thing.
And to arrest you, right?
There are some exceptions to that, but generally, yes.
Okay. And there are exceptions to the warrant requirement for searching and arresting people, are they not?
There are. Yes, Senator, there are.
Okay. Suppose the Florida Supreme Court ruled that here in Florida, we're not going to recognize any exceptions to the warrant requirement. You have to have a warrant to search someone, and you have to have a warrant to arrest someone. Mm-hmm. No exceptions. Can the Florida Supreme Court do that?
Well, Senator, under the Supremacy Clause, they'd be bound by what the Fourth Amendment dictates. Of course, they're free to make their own requirements as it...
What if the Florida Supreme Court did it under the Florida Constitution and not the federal Constitution?
Well, they would still, Senator, have to apply with what the federal Constitution said.
No, they wouldn't.
Under the Supremacy Clause.
Do you know what adequate and independent state grounds means?
Sure. Of course, I would understand that they could have independent and adequate state grounds for state law, but they...
No, they don't. As long as you don't take away rights, mm-hmm. but add to them, a state can do whatever it wants to under its state constitution, can't it?
Yes, sir. Yes,
but that's not what you just said. You think the Supremacy Clause applies? The Supremacy Clause applies.
Well,
you want to change your answer?
Senator, I would like to change my answer to the extent that I agree with you that the Florida legislature, Florida could do exactly what you said. I meant in my statement is that...
Trust me, it can. Judge Pruitt, I'm sorry, I can't see that far.
It's Judge Pratt, Senator. Yes.
Judge Pratt, I apologize. I can't see that far. Can a state legislature pass a law that discriminates against a group of people over another group of people for inferior treatment?
Well, Senator, the federal Constitution and the state Constitution both contain protections against various forms of discrimination.
But can a state legislature say we're going to treat this group of people differently than another group of people?
So I think, Senator, an example where a legislature
could... Tell me first if a state can do that.
Yes, a state can, for example, require a driving age which discriminates on the basis of age. To say, for example...
When can a state legislature not do that?
When it's seeking to do so under a basis that is protected under the state or federal Constitution.
Okay, good. Judge, tell me about the privileges and immunities clause.
The Privileges and Immunities Clause, there's a privileges and immunities and a privileges or immunities clause. There's one of each. One of them relates...
Privileges and is what I'm asking you about.
I believe you're referring to what came through in one of the Reconstruction amendments in discussing the fact that that the privileges and immunities of citizenship would be extended under those.
First, what article is it in?
I believe it's in the 13th Amendment.
No, 4th. Article 4. What does it do?
Senator, you have pinpointed a question that in my 9 years as a judge, in my decade of private practice before this, my 2 years as a law clerk, my 2 years on law review in law school, including a year as editor-in-chief, didn't ever come up.
You tell me you don't know?
So it's an interesting question.
Yes,
and
ma'am. I know it's interesting. That's why I asked it.
Yes,
but you don't know the answer. Just tell me. I got a lot of ground to cover here.
I would be very happy to research it.
Okay. Do you know what the privileges or immunities clause is?
With respect to my answer would be the same on that.
You don't know it either.
Well, with respect to the privileges and immunities of citizenship, my recollection is that
privileges are immunities.
Yes, my recollection is that was discussed in one of the Reconstruction amendments.
Which one do you know?
I believe it was the 13th or the 14th.
All right, Judge. What's Title VI of the Civil Rights Act of '64 do? Ma'am?
Which judge?
This judge down here on the far end.
Artau?
I can't see that far.
Just making sure, because there's 4 judges there. Judge Artau, I'm going to let you answer that briefly.
Hey, I want to reclaim my time, Mr. Chairman.
You can
Madam
answer
Chairman.
that briefly.
Judge, what's Title VI of the Civil Rights Act do?
I believe that ensures that people are treated equally in any places that they would be, that they would not be discriminated against.
In all cases?
Refresh my recollection as to what you were referring to,
I'm
Senator.
referring to Title VI of the Civil Rights Act of 1964, which you're going to see every other Thursday as a federal judge.
So I believe that's under the Commerce Clause. They wanted to make sure that there was not any discrimination going on with regard to race, and that was addressing it.
It prohibits discriminating on the basis of race or color or national origin. Under what circumstance? Do you know the answer?
Under any circumstances where you're providing services to people.
No, it's only if you're getting federal money. You need to brush up on that one. I'm way over my time. Thank you, Madam Chair.
Thank you, Senator Kennedy. Senator...
You could practically hear the Constitution begging for help. That's how embarrassing this was. Senator Kennedy just exposed a shocking level of ignorance from Biden's judicial nominees. People who, if confirmed, would sit on the federal bench for life, judging your rights, your freedoms, your future, and yet they couldn't even explain basic constitutional principles. Let's start with Judge Dudek. Kennedy asked her the simplest legal question imaginable. What's the warrant requirement? She fumbled, stuttered, gave a textbook half answer, and still got it wrong. It wasn't just nerves, it was clear she didn't understand the interplay between state and federal law. And Kennedy, with his signature Southern charm masking a razor-sharp logic, dismantled her line by line. When she contradicted herself on the supremacy clause, he didn't raise his voice. He just exposed the contradiction and gave her a chance to fix it. And still, she blew it. Now imagine this person presiding over a criminal trial. Imagine your rights depending on her grasp of federal constitutional limits. Terrifying. Then came Judge Pratt. Kennedy asked a foundational question about discrimination. Can a state legislature pass a law that treats one group worse than another? Again, we got the same evasive, meandering answer. Not once did she firmly assert the constitutional protections that should have been second nature to any real constitutionalist. Instead, she tripped over herself explaining that age-based driver's licenses count as discrimination. I mean, really? Kennedy's brilliance isn't in shouting people down, it's in asking the right question and letting their answers implode. And that's exactly what happened when he shifted to the Privileges and Immunities Clause. Let me be clear. This clause is bedrock federalism. If you've spent a day in constitutional law, you should know it's in Article 4, not the 13th Amendment. But when Kennedy posed this question, you could almost hear the brain gears grinding to a halt. One nominee launched into a resume flex. 9 years as a judge, law review, editor-in-chief, blah, blah, blah. but couldn't give a straight answer about what the clause does. Kennedy wasn't impressed. Neither were we. But the real kicker? The nominee didn't even know the difference between privileges and immunities and privileges or immunities, two totally distinct clauses with different constitutional purposes. This is Law 101. And yet, silence, blank stares, mumbles, deflection. Next, Kennedy moved to Title VI of the Civil Rights Act of 1964. You know, the part that prohibits discrimination based on race, color, or national origin if you're receiving federal funds. This is not obscure law. If you're on the bench, you're going to deal with it constantly. But again, the nominee couldn't articulate it. She wandered into vague generalities about treating people equally in places, and when pressed on when Title VI applies, she guessed, under all circumstances, wrong. The correct answer is only when federal funds are involved. Kennedy had heard enough. So let's talk about what this really means. This isn't just about legal trivia. These are Biden's picks to serve lifetime appointments on federal courts. And they can't answer basic constitutional questions that any second-year law student, heck, even a halfway informed citizen, should know. And yet the left wants us to trust these nominees because they check the right diversity boxes or because they're committed to equity. Sorry, but equity isn't a substitute for competence. And this exchange proved that beyond a doubt, here's the truth. Democrats aren't nominating judges who revere the Constitution. They're nominating activists who barely understand it. They're sending unqualified ideologues into the judiciary, hoping they'll rubber stamp progressive policies rather than uphold the rule of law. Senator Kennedy didn't humiliate them. They did that all by themselves. He just held up the mirror. And to be honest, watching it unfold was painful. Painful not because it was brutal, but because this is the future of our justice system if we don't stop it. If we keep letting nominees like this through the gate, we won't just lose respect for our courts. We'll lose the Constitution itself. The very idea that knowledge and judicial integrity could be traded for slogans and partisanship, that's the death of liberty. This is why elections matter. This is why judicial nominations matter. This is why truth and competence matter. And that's why we need more John Kennedys, not fewer. More senators willing to ask the uncomfortable questions. More fighters who expose the rot under the polite surface. More voices that defend America not with empty buzzwords, but with the actual words of the founders. Because the Constitution isn't optional, it's not flexible, it's not up for reinterpretation based on lived experience. It's the law of the land. And if you want to sit on the federal bench, you'd better damn well know it. So next time you hear the left scream about protecting democracy, ask them if their judges can name the basic clauses of the Constitution. Because after today, we know some of them can't. And we're watching.